Start. However, nothing of the aforesaid principles could apply to the present case, for there had been no material on record and no other reason appeared during trial for which, the trial court would have been obliged to take recourse of the procedure contemplated by section 329 CRPC. Full stop. Similarly, the suggestions about defect in trial or failure on the part of the investigating agency to get the appellant examined through psychiatrist with reference to the decision of the Bombay HC in case of Ajay Ram Pandit within bracket supra bracket close remain too far stretched. Full stop. In the said case, it was noticed that the investigating officer became aware of the fact after apprehending the accused that he was mentally unstable and in fact, the people in his locality used to consider him as a madman. Full stop. The fact situation of the present case is entirely different. Full stop. In the given set of facts and circumstances, we are not dilating on the other decisions cited by the learned counsel for the appellant for being not relevant for the present purpose. Full stop. Fact of the matter in the present case remains that there is nothing on record to show that the appellant was a person of unsound mind, whether at the time of commission of crimes or during the course of trial. Full stop. Apart that there was no fault on the part of the trial court or the investigating agency, it is also noteworthy that contrary to even a trace of want of mental capacity of the appellant at the time of commission of the crimes in question, the manner of commission, with strangulation of the children one by one, semicolon, throwing of their dead bodies into the canal, semicolon, appellant himself swimming in the canal and coming out, semicolon, and immediately thereafter, stating before several persons that the children had accidentally slipped into the canal so as to project it as a case of accidental drowning, if at all, show an alert and calculative mind, which had worked with specific intent to cause the death of the children and to cause disappearance of evidence by throwing dead bodies into the canal and thereafter, to mislead by giving a false narrative. Full stop. By no logic or by no measure of assessment, the appellant, who is found to have carried all the aforesaid misdeeds, could be said to be a person of unsound mind. Full stop. Thus, we are clearly of the view that the appellant was neither suffering from any medically determined mental illness nor could be said to be a person under a legal disability of unsound mind. Full stop. Hence, neither section 84 IPC applies to the present case nor section 329 CRPC would come to the rescue of the appellant. Full stop. The suggestions about treatment of the appellant for his abnormal behavior in jail also does not take his case any further. Full stop. There is nothing on record to find that the appellant was a person of unsound mind at the time of commission of crime or was a person of unsound mind when tried in this case. Full stop.